I am pleased to introduce the next speaker, a visiting professor at the University of North Dakota, Christine Fritze.
First of all, I want to welcome all you guys. This is awesome. I'm, as you can probably tell, not from North Dakota. I'm from Oklahoma and practiced for about 20 years in oil and gas, primarily class action work the last about 10 years, which we'll be doing a presentation this afternoon on. So that's kind of where I came from, teaching oil and gas and natural resources at the university this year and next year. I want to, first of all, thank some of my students who kind of brought this whole Migratory Bird Act, and you go, really? We're going to talk about the Migratory Bird Act, some of you. It's actually more interesting than you might think. And it really does have a direct application to the oil and gas business. So that's what they kind of brought to my attention. I had not paid any attention to that before. So I had these students last fall in a natural resource class. They did a paper, different aspects of the Migratory Bird Act, and so that's kind of what got my idea for doing this today. This is just a picture of the migratory tracks for the birds, and you can see they're internationally, so we all know that that's a problem. It can be a problem with controlling how they're taken care of and the extinction and so on and so forth. You would not, these are some of the numbers of birds that are killed from all types of sources. This is from the U.S. Fish and Wildlife Service. So this is what they estimate, that up to 976 million birds are killed from hitting glass windows, be it because they're cleaning them well with the Windex or if it's your car or whatever, but we're killing a lot of birds that way. 174 on transmission lines, 72 because of pesticides, approximately 60 million because of cars, 39 million because of domestic cats. They don't even know the number of that are killed by feral cats. 4 to 5 conservatively from communication towers. And this service said that there was 33,000 a year from wind turbines. And I'm going to talk about that just a little bit, but some other sources say that it's between 100 and 400,000, and that's going to be increasing, as you can well imagine, over time. So these are numbers that are huge in numbers. So the numbers that are being killed in the oil patch are so small that it kind of creates an issue of scale that we think, why are we even talking about this? But we are, and the government is, and so let's talk a little bit about just some numbers just to kind of put everything in perspective. The Federal Wildlife Service also says that from production skim pits and wastewater disposal facilities, that in 1997 they estimated a couple of million, and now they've brought that back. And they attribute the change to be because of regulations, them going out, setting the regulations, and the industry doing a better job at issues about pits, putting screens on, things such as that. So that's what they attribute the actions to the operators in bringing this number down. And all these numbers are just an estimate because we really don't. It's really, really difficult because of what happens to the birds if it's not killed in an oil pit. If it's killed because it hits a turbine, falls on the ground, it's going to be eaten. And so there's a really, really big problem of estimating numbers of actual birds that are being killed from various sources. But this is what the Federal Wildlife Service is estimating, that there was a change. So so when we talk about the Migratory Bird Act and birds and so on and so forth, it starts back in Law School 1 property class with Pearson versus Post, and you know, we started with that. This is just a little bit of the history of how we got the act, but we've always looked at wildlife as something we own, something we possess, something that is for our benefit to the extent that we want to use them. And up until around the 20th century, wasn't really a big issue. we didn't have enough effect on birds to really cause them enough harm that anyone got really very concerned about it. So, but this gives the statement that when you reduce it to possession, then that's how we own an animal, and so therefore, and that's the concept, we own them. They're for our benefit, our use. But then this started happening, and you say, a hat? What happened is, around the turn of the century, there were a couple of things that were happening. One was hunting for restaurant. It became very vogue to be eating wild birds, so there was a need to hunt. There was just the sheer, like the bison, just the sheer hunting for the joy of it, and that was desecrating quite a few. And then we had feathers for fashion, and that really seriously took a big toll on the migrating birds. So that was the millinery industry is a big part of why we have the Migratory Bird Act. Little FYI. So, and looking at the history of the progression of the act itself, the first attempt, there were hunters that became concerned. It wasn't just your hardcore environmentalists. They were concerned about the future of having enough birds to hunt. So in 1913, the Congress just passed an act. But that did not last because the states attacked it on states' rights, and it failed for constitutional reasons. So we had to go back and rethink, what can we do? How can we accomplish the same means? So they got together with Great Britain on behalf of Canada, and in 1916 they passed the Migratory Bird Treaty. Now, in the United States, treaties are not self-implementing. So a treaty can be, the United States can enter a treaty with any country in the world, and it can just sit there, and until Congress passes an act, it has no effect. So then 2 years later, Congress passed the Migratory Bird Treaty Act. So what they were able to accomplish, they kind of went around the end and accomplished getting something passed because Congress can, through its treaty powers, pass treaties with other countries that they might not would be able to do through just passing legislation in the states, and that's exactly what happened here. So in 1916, we entered the treaty with Great Britain on behalf of Canada, and then eventually in 1936, we added Japan, or Mexico. 1972 was Japan, and 1976 was the Soviet Union. So that has been the extent of the Migratory Bird Treaty and how far it has reached. So, and this, we have other acts. There's the Endangered Species Act. There's the Golden Eagle Protection Act. So we have some other acts as well. But this for today's purposes, and usually when these companies are charged, they'll be charged under more than one act. But we're just going to concentrate on the Migratory Bird Treaty Act today. So here is the provision in the act that's getting all the attention, and it is actually getting quite a bit of attention. The act just says, this is the section of the act that discusses, this is one of the prohibited activities, and it's, they use the word taking, killing. So it shall be unlawful at any time in any manner to pursue, hunt, take, capture, kill, attempt to kill, capture, or kill any migratory bird. But this language has not changed since 1916. So if you think about, there were no cars weren't an issue, all that whole list, there wasn't anything on that list that caused any concern to Congress or Great Britain at that time when they were passing this act. It was hunting and poaching, and we needed, even to the extent they were using nests for hats, for decoration. So this was the original language. That has not changed. And then the violation itself, it's a misdemeanor. There is a felony provision as well. The misdemeanor provision is up to a $15,000 fine. That was changed in 1998. The $15,000 went from $500 to $15,000 as of 1998. So that's the misdemeanor. And there's no mens rea. There's no, this is a strict liability statute on misdemeanor, which brings up why there's so much controversy about, one reason there's so much controversy about the statute. The felony section was changed in 1986 to add the word knowingly. So prior to 1986, the felony statute had no knowledge, it was a strict liability as well. But they changed that because it did run into constitutional issues for felony, because there are the greater risk of being put in jail. So that's been the only change to the two sections that control whether there's a crime permitted. So if you look at the 707 section, you can just see, literally, if under this statute, if your child goes out in the backyard and finds a nest with bird eggs in it that's fallen to the ground and says, "Oh, yay, Mom, look here," and your next door neighbor happens to be a rabid government agent and says that those are a migratory bird egg, you blow them out, make them decorative, and put them on your table for Easter, and you think all's good, the birds are dead anyway. That's a violation of the act, and you could be charged. And we would hope that would never happen, but that's the fear, and that's one of the reasons that these cases are all over the place, not just in the oil and gas area. So having the strict liability is where the problem comes in. Now, they do take a definition. There is no definition for take in the act, but they look at the CFR, which is really a lot of help, because it says to pursue, hunt, shoot, wound, kill, trap, capture, collect, attempt to pursue. So it just repeats. It doesn't really give us any more guidance on what a take, what's required to have a criminal violation under the act. So the right now the status of the affair in the United States are the federal courts are completely split, don't know what to do with this. It comes up quite a bit in two instances: pesticides and oil and gas. And so the Eighth Circuit, these are cases where there was strict liability and they found an exception for legal commercial activities, which is what had been argued. So in the Eighth Circuit, this Newton County wildlife case, that had to do with timber sales. It didn't necessarily have to do, it was actually trying to prevent the sales because it was going to, an environmental group had gotten involved and it was going to affect the habitat. And so they got involved. And the court in that case said, no, that's okay. They can sell the timber. That's not the type of activity that was intended to be covered by the act. The Ninth Circuit, there's a case out of the Ninth Circuit that's actually, the Eighth Circuit was actually an appellate decision. So, but a lot of these are just district court decisions. The Ninth Circuit, another BML sale of lumber. Again, the Ninth Circuit found that that's okay, that that's a commercial activity that wasn't intended to be covered by the act, and therefore there would be no violation of the Migratory Bird Act by doing that. Some of these circuits actually have a conflict within there's district courts going one way and district courts going another, so it's not just one district court going against one circuit going against another circuit. We actually have dissension within the circuits. In the 10th Circuit, there's a New Mexico case where a district court judge dismissed a claim because he said that it was ambiguous, the language was ambiguous, that was not the intention under the act. And so this is a 10th Circuit, this is an oil case, so it was an evaporation pit, and that's a 2009 case. And he specifically said that Congress intended to prohibit only conduct directed towards birds and did not intend to criminalize negligent actions or omissions that are not directed at birds, but which incidentally and proximately cause the bird's death. And he's citing out of another case. So he actually, the case that he cites to, State v. Chevron, that judge actually rejected a plea agreement because they were going to enter a plea agreement, and the judge said, no, there's no violation here. I'm not accepting this. I'm dismissing it. So those are examples in the Tenth Circuit, and in a minute we're going to see examples in the Tenth Circuit that go the other direction. In the Second Circuit, this U.S. versus FMC Corp., this is where they have held strict liability, and they say there's no exception for commercial activities. And this one, 92, it's actually went to jury trial all the way through jury. Most of these do not. They either companies are making plea agreements, entering into plea agreements, or they're being dismissed on the information. So at the preliminary hearing stage. So not very. I have not seen very many examples of them actually going all the way to jury. In this case, there were 92 birds that died, but they only got convicted on 18 of the 36 counts. And that's been another question. Does each bird is a separate count? I would personally think there'd be problems with proof of, did the pit kill the bird, or did the bird die and fall in the pit? I don't know how you prove that, but I would think there would be a proximate cause issue there I would want to raise anyway. So, and he also, this judge went all the way back. This is actually appellate, and cited Rylands v. Fletcher, which is another 1865 case about hazardous activities, and said, when one enters into a business or activity for his own benefit, and that benefit results in harm to others, the party should bear the responsibility of that harm. So that was his basis for finding that there were strict liability and upholding the conviction from the jury trial. This Corbin Farms case out of the Ninth Circuit is they produced a pesticide, and their pesticide pond that they had some way or another was a clearing pond, leaked onto an alfalfa field. The birds ate the pesticide and killed the birds. So this judge said that even though he recognized that the primary intent was hunting and poaching, he also recognized that it said at any time, by any means, or in any manner. So he looked at the literal language of the statute and said, I don't see an exclusion here. So that's, and there were 12 counts, and they were also under this Fungicide and Rodenticide Act. So there are more than one way they go after on these cases. So here we are back at the 10th Circuit, maybe. This is a 1990 case. This is an electrical power case, and the court said that they had noticed, that they knew that there were things they could do, and that's often the case too. They've been warned. There's things they could have done, they didn't do. Now we're going to come and prosecute you. So, and again, here it was the jury's province to determine whether the defendant took or killed. So it was a jury question, and they added the knowingly. They put a knowing and wantonly disregard. So these judges are adding that into the statute, even though the statute does not say that. There's another 10th Circuit case that these were oil well drilling operators, and this was a heater-treater situation. And this one is a little bit interesting because, and again, it's knowledge. This is a misdemeanor case, but in 2007 they found one dead protected bird. Apollo's. There's two defendants here. There's Apollo Energy and there's Red Cedar. Dale Walker doing business as Red Cedar. And then there were 4 birds in Dale Walker's heater treaters. And in 2008, they went back out and found another dead bird. So we're just talking about a few birds here, but they went back out 2 years in a row and kept finding these birds. And this court found that you had to have some knowledge. You had to have some reason to know that your behavior would cause you to possibly violate the statute. So again, they're kind of adding this knowingly into the statute. So he says that the Treaty Act was vague, unconstitutionally vague. So, and therefore, what he ultimately did, he found that Dale Walker could not be charged with the first death because he didn't have notice. So once the first death, he could be charged with the second death. So they're even though they're finding strict liability in a sense, they're also kind of adding this knowingly and willful into the statute. So, Mark, recently what's happened is, and this is what you see really in most of these cases, there's a lot of companies that are just entering into a plea bargaining, paying their money, and thinking they're going down the road. That could be a very serious issue, especially if you are on federal lands, because the BLM and they have come up with guidelines and regs, and federal leases include that you have to comply with the laws and the regs that apply to your lease. So if you're going out and pleading to a misdemeanor, in this case they paid $22,000 and $7,500 to a nonprofit, but theoretically you could lose your lease if somebody wanted to take it that far. So there's, even though it may just kind of be a nuisance issue for oil companies, it could evolve into a bigger issue if, depending on what the government wanted to do. So I would say that, companies should be a little more cautious about just entering into these plea agreements, especially if they're operating on federal lands. In this case, they had three. This is actually in Colorado, or the headquarters not in Colorado. There's actually violations in Montana, Wyoming, and Nebraska. And so they entered a plea agreement. They admitted to the guilt. This was on temporary ponds. And the fluid in the reserve ponds, of course, have chemicals in them that are going to be detrimental to the birds. And they, again, notice of way. They've been told what to do to make these pits safer. And so that is a big reason that the government comes in and finally prosecutes these guys. They come in, they've told them, look, if you'll do this, you'll do that, whatever, you'll be in better shape. So in 2005, they had some birds documented some birds on an unnetted pond, and so they notified them that they found 12. And then eventually, in 2007, they conducted another inspection, and they found some more dead birds. And so that was counts 1, 2, and 3. In 2008, they found some more birds, and in all cases, they agreed in this plea agreement that those deaths were caused from the liquids that were harmful that were found. So after some more, after they addressed the mortality rate again in 2009, they hired, the oil company hired a company to come in and say, what can we do? What can be done better, different, whatever. So they actually made some efforts to try to change their procedures to perhaps save the birds. And this is all, these slides are all out of the plea agreement. I just pulled this right out of the plea agreement. So this is what they agreed to and signed off on and stipulated to. But the court did find that because of their actions in cooperating and reporting what they'd done to try to change hiring Nance, that because of that they reduced their fine, and they gave them a break on that. So they actually recognized that, but said, oh well, it's still a strict well, and actually it was a plea agreement. So, but of course, you know, in the other case we saw where a judge said, I don't care if it's a plea agreement, I'm not going to find strict liability. So they ended up agreeing to pay the $22,000. They agreed to pay $7,500 to this American Wetlands Conservation Fund, and then they had a continuing duty to work with the Forest and Wildlife Service to continue monitoring what was going on. So to do this environmental compliance plan. And that brings us up to North Dakota. See? Have to be patient. It'll get there. So in North Dakota, last year we had a case that, and it was Judge Daniel Hovland. I'm still learning all these names. I don't even know how many circuits. I mean, how many district courts, federal courts are there in North Dakota? Okay, so they sit in two different places. Okay, thank you. So, you know, there was a case that was filed. It's one case. It was originally filed against 7 defendants. 3 of those defendants were Brigham Oil and Gas, Newfield Production, and Continental. So they initially charged all 7 of them with violations of the Act of Class B misdemeanors. The information language, this comes out of the information, not exact language, but I'm not trying to quote. And it just says they're charged with taking, and they're all 3 the same, found dead in one of their reserves pits. And then Newfield was found dead on a property located adjacent, and Continental is charged with one bird near one of its reserve pits. 3 of the defendants pled out. So, and one of them was dismissed for whatever reason. So we're left with the 3, and they took it. And it did not go up on appeal, as far as it did not go up on appeal. So the district court dismissed against the other 3, against Brigham and Continental and Newfield. And this is the allegation in the information. And it says, without permitting to do so by regulation as required by law, did take. And then it quotes these birds. And the judge says that the information does not contain an explanation of the phrase without being permitted to do so by regulation as required by law. The information doesn't give them notice of what regulation that they're talking about there. So you can kind of see he's pointing a direction on which way he's going. And it doesn't explain how they took them. And again, I think I would argue proximate cause. Can you check for a heart attack on a bird? I don't know. So he recognized, the federal district court judge recognized that North Dakota state law defines what a reserve pit is, sets the requirements, and does not require those to be fenced or screened or netted unless such pit is not reclaimed in excess of 90 days after completion of operation. So pursuant to state law, there is no requirement to net these pits. So if you're not on federal land, if you're on federal land, the feds can tell you to do it. But if you're on private lands, the state of North Dakota controls on that. So there could be a conflict. Well, there is a conflict between what the state of North Dakota has said you can do and be legal, and what you can do under the Migratory Bird Act. So this is the district court still in the Brigham case, said that it shall be unlawful at any time by any means or in any manner to take any migratory bird. In the context of the act, take refers to conduct directed at birds such as hunting and poaching, and not acts or omissions having merely the incidental or unintended effect. So the district court in North Dakota recognized that we're looking at what the act's original intent was. The original intent of the act was towards illegal hunting, illegal poaching, taking these birds and using them for commercial purposes. That was or for sport. And so and then he goes on to say that the ordinary meaning of the word take says intentionally reducing the wildlife to possession. And that's just the dictionary definition, to get one's hands on possession, power, control by force. So under the strict, just go pull out common sense definition of the word take. Take doesn't really get us to the point of what activities are going on here. I don't really know why that this is where they've chosen to concentrate, because the statute also says kill. So I don't know that you even had to go to the word take, but that seems to be where everyone has really latched on, trying to use the word, what is a take? Is it a take under the statute? The district court in North Dakota recognized that this was that the government is using an expansive interpretation of the Bird Treaty Act, and that when we're talking about criminal sanctions, that should be a narrow constriction. So and the language was vague and ambiguous. He found it to be vague and ambiguous, and take or kill denotes intentional behavior. So that's the status of the act in North Dakota, and probably what it ought to be. But the problem we have is that there are district court cases. There's a Texas case that finds strict liability. As I went through there are cases in the same in the same circuit, that one's finding, one's not. We've got people that are entering plea bargains. So we've got this whole gist of what's going on with the Migratory Bird Treaty Act and the criminal ramifications. And again, I can see a bigger issue if you're on federal lands. That could be a really big issue for you if you're an operator who is on federal lands in North Dakota. So does not appear to be any efforts to take it up. I don't know what's going on at Congress, and that's what the North Dakota judge recognized. This is something that Congress needs to address. We definitely have a conflict. How do you know from state to state, even from within a circuit? You can't even rely on one circuit, because right now we don't, and most circuits don't have a circuit case that even tells us what we're going to do. And again, as I said earlier, we could have situations where very innocent activity could be, and I'm not an alarmist, but I do think it's possible that we could get a zealous prosecutor. No, those don't exist, who decided to make an example out of somebody and prosecute. Not that I'm making any comment on prosecutors, but if you had somebody who really got, for some reason, over some behavior of a innocent 14-year-old or 15-year-old or 18-year-old, literally finding a nest on the ground and taking it home could be a strict liability. Okay, so any questions? Yes, sir. Absolutely. A farmer if you're in a state, in North Dakota, he's good. Stay in North Dakota. I think we're okay in North Dakota. I think that, in North Dakota, I think your farmer is probably going to be all right for now, until we get some other decision. But that is exactly the issue. Backing into the wind farms, with the advent of more and more wind farms, that's going to be a huge issue. And how do you address it? What actions should they take? Do they need to take? So there's other applications, but absolutely, if he's plowing his field and there's a nest, or he accidentally hits a bird, again, if he had somebody out there and with strict liability, there's really not a knowing or intentional in the statute. As I said, the courts are reading that in to find some kind of mens rea, but they could be at risk. I think, depending on what state they're in. Like I said, if they're in where's Haviland? Is he whichever side of if he's in the right district in North Dakota, we know he's probably safe. But if he's in the other one, he might not. I don't know. Because we don't have an answer from the circuit.
I'd just like to raise a point of clarification. It sounded as if you had mentioned that because the state statute in North Dakota about reserve pits doesn't require fencing or screening, that somehow the Migratory Bird Treaty Act didn't apply?
No. I did not intend to say that at
Okay.
all. I just meant there's a conflict. I apologize if that's what it sounded like.
Okay.
That controls the state activities, but the Migratory Bird Act would come in over that. So we have a conflict. Is what if I didn't say that clearly, I apologize.
Right, so the violation
we have a
would happen
conflict. We could,
private land or federal land equally, right?
Yes.
Okay.
I'm
thanks.
sorry that wasn't clear. Yeah, there would absolutely be a violation. That could be a violation, even though you were complying with state law. And if you're following the regulations and you read the state regulations and you are not up on not thinking Migratory Bird Act, oh, I'm good, I don't have to. So it would be innocent if you didn't. But I apologize. I did not mean to say that would be the case.
Just on a practical question, I understand that in the transmission line cases, workaround solutions like spacing the distance between the power transmission cables is helping because the wingspan of the birds isn't, connecting and creating a circuit. Just going forward, are there any practical workarounds with evaporation pits that we should know about? Above and beyond traditional noisemakers, those types of things?
Other than some type of netting or screening, that's what the primary. That my understanding is that's the primary thrust of what the Bureau of Land Management and the Forest and Wildlife Services are advocating. They have done some papers on actions that can be taken that are real easy to find on the internet. But yeah, that's about it that I'm aware of, and I'm sure not the be-all, end-all for sure.
Hi, Professor Fritz.
Hello, Miss.
I'm just wondering what your personal feelings are about a proper way to resolve this controversy about what the scope of the Migratory Bird Treaty Act should be.
I think Congress ought to address it directly.
Just directly address it.
I think Congress should address it, make exclusions, or put some kind of parameters, put some kind of knowledge or something in so that we can so we'll have a consistent behavior throughout. Everybody knows everywhere what's expected of them, since it is a federal act.
Okay. So legislative correction with a mens rea, and there would be
That I think
Probably
that's
that's
absolutely what needs to happen. And something will happen if somebody loses their lease on a federal land. Then we'll appeal it, and that would go up. But until we get something of that magnitude, I don't. It's unlikely that it'll go up to the Supreme Court.
Okay, well, I guess I'll ask one, Professor Fritz. Do you, and maybe you touched on this a little bit, but do you have a recommendation about how you think the circuit split should be resolved?
As far as the circuit split, my personal feeling about it is that I think that there should not be strict liability. There should be some type of a knowingly. That's just my personal opinion, not to be seen as the opinion of the university or whatever that language, that disclaimer language you're supposed to have. But, if somebody would take a case up to, go ahead and appeal it up, then we would be able to make a determination. But again, the cost effectiveness of that like I said, unless somebody loses a lease, these are kind of nuisance. I think the industry is looking at this as a nuisance case. $22,000, $7,500, we'll put the nets on, it'll go away. But if you ever get into the situation where you're on federal lands and you lose a federal lease because somebody comes in and charges you with a misdemeanor and you're guilty of that, and then they follow that up with cancellation of your lease, that would probably get enough attention to find its way up through the courts.
Professor Fritz, I was just wondering, given the current state of the law, what are some of the recommended best practices for oil and gas companies who may encounter problems with this act?
I think that was answered with gentleman's question over here, that the best practices are going to, there are some devices that could be placed on the pits, checking them frequently. I know that because especially during rainy seasons, if you have standards for how often they need to be checked, some of these cases, when it was a rainy season, they overflowed. That was a problem. Fencing them off, putting some kind of netting on them. But you even have to go back because in one of the cases there was netting on the pit, but because of rain, it had overflowed. So that was, wasn't enough to prevent the death. So, so there needs to, you're going to have some kind of policy of checking the pits often, and especially if you're in an area, not if you're in Oklahoma. We had water rationing in January of this year for our yards. So we don't have a big problem with pits running over from extra water. But if you're in, like this spring up here, this will be my first spring up here, as it was my first winter up here. So, but I understand there's a lot of water. I don't know about out west, so it could be a problem. So putting in place systems and practices that would check these pits pretty often would probably be a good practice.
One of my clients is the Fish and Wildlife Service. So I just, and they have an office here in Bismarck. So I would just like to offer, if anybody has questions about what the best practices might be for avian protection, I suspect they really would be welcome.
And why weren't you on the panel?
A phone call. They'd welcome a call and would give you the best information they have available, honestly.
Thank you.
Does a company have any responsibility to report any downed birds or killed birds, and if so, who do they report it to?
I don't know. Let's ask our experts from the Field and Wildlife. I really don't know what there's nothing in the act that creates any responsibility to report. So I don't have it. That's a good question, but I don't know. Self-reporting? Not that you're aware of? Yeah. And again, I'm not really sure how they prove what caused the death of the birds. I guess they can.
I know my colleague Lyle Whittam might have answered this as well, but my name is Deborah Levchik, and I'm the Office of General Counsel, Base Electric Power Cooperative. Many of our projects end up going through the National Environmental Policy Act in a Section 6 consultation. And when you do a workout with the U.S. Fish and Wildlife Service, such as we do with our wind farms, often part of that process in identifying conservation measures is a program for self-reporting any avian mortalities near those structures.
That's part of the EPA.
Yeah,
I mean,
part of the NEPA process.
The NEPA process, yeah. So, and again, I'm, like as I said earlier, there's a lot of other acts that come into play here. You've got, when you're doing a big project, especially, you have the National Environmental Protection Act. So there's other acts that might, although that doesn't tell you what you have to do, it just tells you have to think about what you're going to do. So there's, this was not intended to be an all-exclusive that covers everything, but that is a very good point, that you're going to come up with these plans within working with, especially if you're a project that has a government oversight, such as an electrical plant or line.
Okay.
Well, thank you for your attention.